Two cases on the calendar for this morning. The first case is Thomas v. Secretary of Kansas.
May it please the Court, Jim Miller from Jacksonville, counsel for Daryl Thomas. First, I'd like to reserve 3 minutes for rebuttal. Your Honors, as to my first issue in the brief about the jury selection issue, I'll just relay out my arguments in my brief unless the Court has any questions. As to the second sentencing issue, as to the Prendy v. New Jersey argument that I made in my brief, after we filed all the briefs, this Court has already decided that issue contrary to my position, so if you have any questions, I'll move on to, I think, is the real issue in the case. The issue here is whether the 50-year sentence imposed upon my client, Daryl Thomas, who was 17 years old at the time of the crime, complies with the decision of the United States Supreme Court in Graham v. Florida.
Okay. Mr. Miller, let me have a little discussion first about preservation.
Yes, sir.
You argue that the defense counsel's statement that he was renewing all of his old objections was sufficient here.
Yes.
Didn't the trial court, weren't there a number of issues that were in the air at that time, and didn't the trial court ask clarification about exactly what he was preserving? And he did not specifically refer to the peremptory strike issue, as I read the record.
You've read the record correctly, Your Honor.
Now, explain to me how this was preserved.
Well, my argument is, Your Honor, and look, I'm the first to admit this is not a textbook preservation by anyone, by all concerned, in my opinion. I think it's confusing. Because you get to the end. There's no doubt it was preserved earlier. Didn't get to the end. Of course, the law is you have to renew it. He says, I renew all my prior things. And then you're right. The judge did ask about some discussions of the other thing. And if I remember the record correctly, they just didn't go over this part. So my argument is, by the judge not asking for clarification on that, the judge is accepting the prior thing. That's the best I can argue based on the record. I mean, the real truth is this happens all the time in trial courts. And quite honestly, it's sloppy by everyone involved. Because if there's a question, the judge should say, but really it's not the judge's responsibility, it's counsel's responsibility. But my argument is, Your Honor, that because there was no specific questions about this part of it, in my mind's eye, if I was a trial counsel, if I said I'm renewing all my prior objections, the judge would say, okay, I accept that, except to the parts that were trying to be clarified. Okay, thank you. Thank you, Your Honor. Going back to the Graham issue, the decision of the United States Supreme Court in Graham was this, that life without parole for a client like my client, Mr. Thomas, is unconstitutional. It's cruel and unusual punishment. Now, to answer the issue we have before us today, we have to understand the rationale for that. It's absolutely true. In Graham, this specific issue was not addressed by the court. The facts and the issue before the U.S. Supreme Court in that case is life without parole, cruel and unusual punishment. The court said that it was. My argument here is that when you look at the rationale under Graham and the reason for that decision, and you take that and you apply it to the facts of this case, the sentence in this case is also cruel and unusual. Why? Because 50 years is the functional equivalent of life.
Counsel, I would agree, and there have been some sentences in other states where a 100-year sentence or a 200-year sentence certainly is the equivalent of life, especially if in those states they have the 85% rule.
But they don't.
See, that's right.
That's the key. Your Honor, now
the question, this is a line drawing case.
That's right. That's right. Your Honor, as to the California cases cited by Appellee, I want to be really frank with the court. I think I have this right. I went back and tried to understand the Florida parole system. Boy, that's a complex thing. But those cases cited by Appellee, if I'm correct, there is a chance for parole all along during those cases. It's not like Florida where you have to serve 85%. I personally know of no case that's approved a 50-year sentence that you have to serve the 85% before you get no review at all. You see, that's the key under Graham. The rationale of Graham is because juveniles are not as mature, they're not as responsible, and they're not as culpable, must have some chance for review before they get out. Otherwise, there's no different than the adults. And that's the key in this case, Your Honors. Under Florida's system, the only review that Mr. Thomas will get, other than, of course, commutation or parole, which is extra, judicial. That's outside the judiciary. The only review that he gets is the regular 85% review when he serves 85% of a sentence or 42.5 years. Mr. Graham is treated no differently than all the adults. And my argument is that's precisely why it's unconstitutional under Graham. The mandate of Graham is clear. That's why the United States Supreme Court held that life without parole was unconstitutional, precisely because of the effect that for juveniles, because they're not as formed and they may have a chance to rehabilitate, it's simply cruel to make that juvenile be treated exactly like the adult and not get out at all. So if that's logically true, and I'm correct about 50 years is getting to the functional equivalency of life, and I'll talk about that in a minute, then there has to be some different review for juveniles other than the adults. Otherwise, Graham is meaningless in this context.
Is that a question, though, counsel, that must be addressed to the legislature?
Well, that's actually right. Good question, Judge Thomas. Driving over here, I kept thinking, what's the remedy? As anybody win this case, what's the remedy? That's the hard part. You're right. You can't rewrite those rules. You can't do that. I can see that. You're the judiciary, that's not your function. But what your function could be is just simply say this is unconstitutional and advise the legislature you now must develop some system, whatever that is, to give some meaningful review, because that's what Graham says. There must be some meaningful review of these type of cases to comport with the Eighth Amendment.
Now, in Graham, though, they made it pretty clear, did they not, that they were not addressing a term of years?
Well, they said that's right. And the way I read that is, this is, of course, you have the same prerogative as a court. You just address the issue that's before you. The issue, because otherwise, if you think about it, it would have all been dicta in one sense. And maybe it would have been easier for us, but I'm before you now. And we have this decision from the United States Supreme Court, which governs us all, which informs us as to what
But you're asking us to expand it, to enlarge its applicability.
Well, I'm asking you to interpret it. Yes, if you want to use the word enlarge, yes, that's the next case.
Extended, I think.
Yes, right, yes, extended. So let's get to my argument. Now, I admit that based on what I just said and what you just asked, Judge Thomas, under Graham, if this is not the functional equivalency of life, then I guess I'm out of the ballpark, so to speak, because no court has gone that far. So let's talk about that for a second. But before I do that, remember an argument that I made. No matter what you do in this case, I think, well, no, I didn't put that way. You could rule on the whole case. But if you should, on its face, decline my arguments, I think the really only fair thing is to remand this back for resentencing. Because here's what the trial court did. There were several 3.800B motions filed. The Public Defender's Office filed one. I took the case over and I filed another one to raise the issues that I'm before you today to make sure those are preserved. I made this argument about functional equivalency of life in my motion, hoping to get a hearing. I was going to put in evidence to show what the life expectancy is and whether this is actually the functional equivalency of life. And the trial court made all these findings of fact and ruled against me. I never had a chance. I didn't know that was coming. I didn't have a chance to rebut that. And I don't think that the evidence that she relied on is correct. The reason why I don't is those are general life expectancy tables. My man's going to be in prison, and I can demonstrate. I don't mean to put in evidence that really in the record, but what's going to happen is I can put on evidence, and then we have experts to show that the life expectancy is much less in prison than it is outside.
So remind us again of the underlying facts of the crime here.
The underlying facts of the crime, my client and another person were shooting crap, shooting dice. There was an argument, and
he stabbed him, and he's paralyzed from the waist down.
He shot him, actually. He didn't stab him. But
shot him, and he's paralyzed,
he's paralyzed
for life.
Yes, the facts are horrific. And by the way, that leads me to something. I'm not saying that Mr. Thomas can get out after 50 years or even 42 years. All we want is the opportunity under Graham.
And I appreciate that, but the question that keeps reoccurring in my mind is,
yes,
let's say we rule in your favor, we hold that it's unconstitutional, or perhaps on a more limited basis say that you must be allowed to present evidence as to the lower tables in prison, which logic might seem to indicate it could be a lower life expectancy.
Yes, sir.
What guidance does the trial court have until the legislature acts?
Well, that's part of the remedy.
I mean, isn't this whole exercise, in a sense, in the twilight zone where a trial court is told, well, we really don't have parole eligibility in Florida, which we don't.
Right.
There's no parole eligibility since 1983 and for non-capital crimes, and since 1991 for capital crimes. There's
Right.
no parole eligibility. The legislature's not in session until January. There is no applicable statute to
Right.
provide this review. So then the trial court is put in the position of determining what type of sentence creates an alternative type of review.
Right.
In other words, it seems to be apples and oranges.
Well, I'm not asking for that. I think you're putting the cart before the horse. I think the only way, and I've thought a lot about this, about the remedy. I agree, this is the most problematic part about this, if I'm correct. What is the proper remedy? I think all you can do is just declare it unconstitutional and say the legislature must develop some form of review here. I agree with you. We can't just send this back to the trial court without any kind of standards of review.
But I mean, if we hold it unconstitutional, the trial court has to resentence your client.
Well, I understand, but you can do an order that says not to resentence until the standards are developed. Why can't we do it that way?
You mean order resentencing in abeyance until the
Yes. My client, look,
But what if the legislature doesn't act?
Well, then we'll be back before you again, and you have to do something. I agree that's a problem, but I can see no way out of it. All I can do is before you, Your Honor, is say this is unconstitutional. This does not comply with Graham versus Florida. And so there has to be some remedy. We can't just throw up our hands and say, and I understand what you're saying.
But isn't the other remedy having the sentence be for a term of years that is not the functional equivalent of life?
I was just coming to that. That could be a remedy. That could be a remedy. But I'm being frank with the court. That would be perhaps 2 extensions from Graham. I would love for you to do that. But to be frank and honest with the court, as I always try to be, that's beyond what Graham said. And but of course that is another way to do this. All I know is I want some kind of review for my client because he's not treated any differently than an adult. He can't get any review until he's almost 58, 59 years old. And this, it seems to me, that makes a sham of this whole thing. We have to scratch our heads and think real hard about what the remedy is, but there has to be some remedy here if I'm correct. Because if not, then you're right, he's in a twilight zone. He's not going to do anything. I'm into my rebuttal time. Thank you, Your Honor. If you have more questions, I'll save it for that. Thank you.
May it please the Court, Therese Savona, Assistant Attorney General on behalf of the state. I want to start by addressing Judge Van Norwick's question regarding the preservation issue for Issue 1, the jury selection. This issue is wholly unpreserved. It is correct that defense counsel stated at the end of jury selection, I renew all my old objections. However, the trial court asked specifically, what objections are you referring to? Defense counsel stated, I'm referring to the motions in limine that address hearsay evidence. At that point, defense counsel could have easily stated, I renew my objection to prospective juror, Mrs. Lewis, and he did not do so. Therefore, this issue is wholly unpreserved. Moving to the issue of the Eighth Amendment claim. Appellant contends that his 50-year sentence is an attempt to get around the spirit and the holding of Graham versus Florida, and that this is equivalent to a life sentence. However, appellant's concurrent 50-year sentence for the crimes of armed robbery and aggravated battery do not violate Graham because Graham does not apply to a defined term of years. In Graham, the United States Supreme Court narrowly held that juveniles who commit non-homicide crimes and receive a specific indeterminate sentence of life without the possibility of parole, that this violates the Eighth Amendment. And there, it created a categorical rule, and only when the sentence of life without the possibility of parole has been received by a juvenile who commits a non-homicide crime, then a meaningful opportunity of review to demonstrate rehabilitation and maturity is necessary. And that is why Graham doesn't apply to this case, because appellant did not receive an indeterminate sentence of life without the possibility of parole. Appellant received the defined term of year sentence for 50 years. He committed an armed robbery, an aggravated battery, and to correct the facts that opposing counsel stated, this wasn't a fight. Appellant had his gun and saw that the victim went to his car to take out a $100 bill to shoot dice with. the appellant then told another individual that he would leave with him, but he was going to go first rob the victim. The victim was kneeling down, shooting dice, when appellant pulled a gun on him and wanted his money. At that point, the victim feared for his life and thought that he was going to die, and appellant shot him in the back and paralyzed a 17-year-old boy for the rest of his life. He's paralyzed from the waist down. And this is a clear intent to show that he acted alone. He did not act with peer pressure. He acted intentionally to rob this man and to rob him of the rest of his life. He will no longer be able to walk. And the bright line rules, very simply stated, the bright line rule of Graham just does not apply. There is no equivalent to a life without the possibility of parole. Graham is steadfastly silent as to whether or not there is a defined term of years that could be equivalent to life. And Justice Alito specifically cites that in his dissent. If this court has no further questions, the state will rest on its brief and respectfully request this honorable court to affirm. Thank you.
Well, you know, like I said, they didn't address this issue. However, you're a court here that can enforce the U.S. Constitution as it applies to a case in Florida. You can do that. Look, if the state's right logically about this, then what is the term here? We're going to go back to the way it was when I first started practicing law, when there was parole, and judges would give 400- and 500-year sentences and all that kind of stuff. I mean, there just comes a point where we have to decide, is this the equivalency of life? And, you know, if my client, look, my client may have to serve all of the 50 years. That's okay. That's the way the system works. But then he'll be in his late 60s. And it's true, again, that Graham didn't specifically address this. But it's now before you now. I've raised this below, and what I'm arguing is an extension or expansion, or however you want to look at it. I'm asking you to consider whether Graham applies to the facts of this case and whether under the Florida system. That's the key again. All these other states that we're talking about, they have a different system. There's some way to get out. We don't have parole again. And again, I know the remedy's problematic, but I ask you to find this unconstitutional and just say it's unconstitutional, and the legislature must do something to give some kind of review. Thank you, Your Honor.
Thank you, counsel. Thank you both.